In a custody battle, parents often assert competing claims of superiority as a caretaker, requiring the court to engage in a fact-intensive inquiry to decide the arrangement that best serves the child's interests. In McIntosh v. McIntosh, we explore the factors that courts consider in making best interest determinations. When Mr. McIntosh filed for divorce from Mrs. McIntosh, he simultaneously sought an ex parte order, or one issued without a hearing in emergency situations, granting him sole custody of their 1-year-old son, Jordan. The trial court issued an ex parte order requiring that Jordan live with Mr. McIntosh, with Mrs. McIntosh having reasonable parenting time or visitation. Mrs. McIntosh objected, prompting a hearing that resulted in the judge instead ordering an equal division of physical custody. The shared custody arrangement proved problematic, with the parties routinely appearing before the court for failures to comply and custody exchanges eventually being relegated to the local police station. The trial judge referred the case to the county's friend of court office for a child custody and parenting time evaluation by a psychologist. The resulting evaluation recommended that Mr. and Mrs. McIntosh continue to share custody. Mr. McIntosh subsequently moved to modify the custody order, again seeking sole physical custody. At a bench trial, Mrs. McIntosh presented evidence that Mr. McIntosh withheld Jordan from her without cause, was physically abusive during the marriage, and struggled with alcohol abuse. Based on that evidence, the trial court ultimately awarded Mrs. McIntosh sole legal and physical custody, finding that to be in Jordan's best interests. Mr. McIntosh appealed to the Michigan Court of Appeals, contesting the trial court's best interest findings and its failure to adopt the psychologist's recommendation.